Hi, everyone. Thank you for joining us tonight for the webinar. My name is Gabriela Urizar, and I'm an immigration attorney here at Manifest. I have almost 10 years of experience practicing immigration law, specializing in work visas, and we're very happy to have you tonight here. We're going to be answering some questions, and just a reminder that if you want to schedule a consultation with one of our attorneys, you're welcome to schedule a consultation. It's free. And we're happy to answer the more detailed and case-specific questions, okay? So we're going to go through the first question right now. It reads, okay, so the first question that we have here, Ricky M asks, H-1B approved in 2023 and a renewal in September 2026. Planning to have my first time stamping in India in March of 2026. Given this, how long will the visa be valid for? Will I have to get a new stamp after a renewal? Okay, this is a great question that comes up very often. So we have two things to pay attention, right? We have the H-1B status, which, as we know, is given for a total of 6 years of physical presence. And something that people tend to forget is that only the time that you spend physically in the US counts towards those 6 years. You can always recapture the time and ask for another extension, where you ask USCIS to give you back all the days that you spend outside of the United States. So that's the first thing that we have to think about. The second thing that we have to think about is the visa validity. The visa, the sticker that they put on your passport, only serves as a travel document. And the validity depends on the country reciprocity laws with the United States. So that's why sometimes we have people with passports from, let's say, Brazil, that have a sticker, a visa stamp that only is valid for 2 years, even though their status, their H-1B could be valid for 3 years, because it depends on the visa reciprocity laws. So in this case, you will get a sticker on your passport. It will be valid for as many years as India has the reciprocity with the United States. And you can check this online, and we're happy to provide you with information as well. The visa stamp on the sticker is dependent on your status. So for example, let's say that they give you a validity for until 2028, but your status expires in 2027. You can continue traveling with the visa stamp until 2027 unless you extend your status, because they both have to be valid for you to be able to come into the US. Let's say your status expires before the visa stamp, the sticker on your passport. You can extend the status in the US without having to get a new visa stamp. You can continue to use the visa stamp as long as it's valid and as long as your underlying status is valid. I hope that was clear. Now we're jumping on the second question. NIW I-140 has been pending for the last 13 months. So what would you suggest at this time, given that a premium processing might lead to an RFE, as officers might not be reading the petition carefully? So this is a misunderstanding that a lot of people have. A request for premium processing doesn't automatically trigger a request for evidence. When a petition is filed with USCIS, officers first, they have a protocol to review these petitions, right? Regardless if it's premium processing or regular processing. So officers first scan the petition to see if it's well organized, to see if it's easy to understand, and to see that you provided all the documents that were required. If the petition is very heavy on the wording, if the terms are very complex, if it's scattered or all over the place, regardless if it's premium processing or regular processing, they will flag this application for a request for evidence. So submitting a premium processing request doesn't automatically result in an RFE, and it will definitely help you expedite the process, right? So if you continue with the application on the regular processing, let's say it could take many more months for USCIS to respond. Keep in mind that they could still respond with a request for evidence, right? So this could prolong the time even more. And I'm gonna put in the chat, I'm going to put in the chat, we have an amazing resource here at Manifest. We have created a chart for processing times for different applications. So you can take your time, review the different processing times, and we update these often. So these numbers are pretty accurate. Okay. Okay, we'll be providing. Awesome. Now let's jump to the other question. The NIW I-140 petition rejection rates are extremely high. Further to these, processing times are increasing, so it is futile to file for an NIW I-140 till 2028, question mark. So the NIW I-140 denial rates are not extremely high. They are higher than they were a few years ago because of the demand, right? There was a huge demand, especially for companies with or foreign nationals within the IT world, and they were filing a lot of applications just because they were in the science field, right? So given this, USCIS did raise the denial or the RFP request rates for this type of applications, but we're still seeing approvals for NIW, especially when you're working with a specialized attorney. Filing an application for an NIW is complex. You do have to meet the legal requirements, and having an attorney that has the experience, especially in terms of a strategy and how to portray your case, makes a massive difference in getting the approval. So I can give you an example. I had a consultation with a potential client, very brilliant, very accomplished, but the way that he was going to present his evidence, it wasn't as clear as we should be presenting this evidence. And something to remember is that USCIS officers are not experts in your field. So it is important to present this information in a way that is clear and that is easy to understand. Also to take into account what are the goals of this administration, right? So for example, prior to this administration, we had other administrations that were very focused on renewable energy or clean energy or keeping carbon emissions low, right? That's not a priority that we have seen under this administration. This administration cares a lot about being competitive with other countries, about saving money, about the economy. So if you are putting together your application for NIW, you should keep this framework in the back of your head when you're compiling information that makes your case a strong case. So if you have a strong case, if you're able to put together a strong application and have a good strategy in place, I highly recommend to move forward and apply for the NIW. Again, they're still getting approved, they're still getting reviewed, we're still hearing success stories, so it is important to consult with an immigration attorney. So let's go to the next one. If the H-1B wage increase rule comes to play, will it impact existing H-1B workers at the time of the H-1B renewal next year? Will the new wage have to be forced on the LCA? This is a really good question, and I'm going to have someone from my team link an article. We actually just did a blog about this new rule. So in terms of when, again, this rule has not been approved yet, right? Like it's in the process of being reviewed. When immigration comes up with a new rule, most of the times they're not retroactive. However, when someone applies for an H-1B, even if it's an extension or a renewal or a change of employer, these applications under the regulations have to be treated as a new application, right? Like you have to still meet the requirements, the position that you're being hired for, it still has to meet the requirements. So likely, if the new rules for the wage comes into play, it will be very likely that when you file an extension or a change of employer, that the new LCA will need to comply with the new requirements. Awesome. Okay, we have another question. Let me read it first. What precautions should one take to travel to the home country for the first time H-1B stamping at the consulate under these new rules? The H-1B was approved in 2023. So we have a lot of questions coming up related to the H-1B rules, especially the $100,000 fee that was announced by the current administration. They did come up later and clarified when is this new rule applicable, right? And my team is also going to link a link for a blog and for information that we have if you want to read about these rules into more detail. But basically what this administration has clarified is that the $100,000 fee doesn't apply for petitions for people that, for example, were in the US when the petition was filed, or if they have a prior approval before the rule came into effect. So this narrows down the application of the rules significantly, and we're seeing that it applies solely to people who are outside of the country by the time of the filing and are filing an application for consular notification. Or for example, if someone is here in the US and is going to file an extension of status, let's remember that when we file for an extension of status, we're asking for two things. The first thing is that we're asking for your H-1B status to be extended, so extension of status. And the second thing that we're asking is for the government to issue technically a new H-1B with a new validity. If the government thinks that you had a gap in employment authorization, or if you were here, if you had some time of unlawful presence, or if you violated your terms of your employment in any way, for example, you did a side hustle while you were on the H-1B, even though it was tied to a specific employer, they might approve the second part, the H-1B, give you 3 more years, let's say, on their H-1B status, but they might deny the extension of status, meaning that you need to go abroad at the consulate, at a U.S. consulate abroad, and activate the new H-1B so that you're able to come into the U.S. So in that scenario, the new fee might apply. But in this situation where you're saying that your H-1B has already been approved, especially back in 2023, the fee doesn't apply to you. If you're planning to have your visa stamping for the first time, I recommend that you read into the requirements for the consulate in the city where you're applying for the visa. All the U.S. embassies and consulates have different requirements, and also they have office closures, especially now that we have the holidays coming up. So it's very important to make sure that you know which documents you have to bring to your visa stamping appointment. But generally, you need to bring your original approval notice for your H-1B, a valid passport. If you are traveling with dependents or you want to bring either your spouse or children, make sure that you also bring proof of their relationship with you. So for example, if you want to get your spouse a visa stamping, make sure you bring the copy of the marriage certificate, which shows that you're legally married. If you want to also get your children a visa stamp, make sure that you get your children's birth certificate that clearly says that you're the legal parent, right? And also proof of valid employment. This could be the pay stubs from the last 3 months and an employment verification letter. Most companies are able to give you an employment verification letter through an automated system. Like if you go to your place of employment, let's say human resources website, you're able to generate it. Or if not, you're able to ask HR to give you an employment verification letter to show that you're still employed and that you're still maintaining your status. You make the appointment, you go to the appointment, you show your visa stamping. You don't have to reapply for the H-1B. You just, especially if you have an approval, right? Like it's more procedural. Officers want to make sure that you haven't been arrested, that you don't have any issues, and that you still have valid employment. And the process should be pretty simple and pretty straightforward. Okay. Let's read the second question. Another question, okay? Can an employer stop an EB3 sponsorship midway through the process? If they withdraw, how does this impact the applicant's immigration status? So let's remember that under the EBT category, one of the requirements is to do a PER, right? A labor certification. So it takes about a year for the process of getting prepared to be able to file for a labor certification, meaning testing the market, putting the ads, collecting resumes, checking that no U.S. worker is willing and able to qualify for the offered job, and also getting a prevailing wage determination from the Department of Labor. Once you have all the information that is required to fill out the form for the labor certification, you file it with the Department of Labor. They're taking about a year to approve these labor certifications. After they come back with an approved labor certification, your employer can go ahead and file for the I-140 with the labor certification. If your priority date is current, you can file for the adjustment of status concurrently and a work permit and travel document. If it's not current, then you have to wait until your priority date is current to be able to go ahead and apply for the adjustment of status application. Even at the later stage of possibly going to your interview for your green card, you still have to have valid employment unless you're able to port that I-140 to a new employer. And to be able to port that I-140 to a new employer, the I-140 has to have been filed at least 180 days from the time that you want to port. If you have more detailed questions about this process, again, you can always schedule a consultation with us. We're giving free consultations for people who are joining this webinar and want to speak to an immigration attorney. In terms of what happened with your immigration status, filing a labor certification or going through the PERM process or even filing an I-140 doesn't give you immigration status. The only way to have permission to stay in the U.S. lawfully is when you get to the stage of filing for Form I-485, which is the adjustment of status application process. If you don't depart the U.S. and you stay in the U.S. while that's pending, you are protected and you're able to stay in the U.S. If your employer, again, withdraws that application, your pending adjustment of status application no longer has a basis and it gets denied and you no longer have that protection. This is why it's highly recommended for foreign nationals, even though the ones that are going through the process of getting a sponsor for employment, to always have valid non-immigrant status, right? Either an L1 or an F1 or an H1B, or if you, for example, were on an H1B and doing the PERM application concurrently with your employer and they withdraw the labor certification or the I-140 and your H1B, or they fire you, you still have the 60-day grace period where you can go look for another employer to move that H1B or the other type of visa that you have, or apply to an academic program so that you can transfer to an F1. Okay, let's look at this other question. H1B approved in 2023 and renewal in September 2026. Planning to travel for the first time stamping in India, given this. Okay, so I think we answered to this question at the beginning. So we're gonna move forward. The other one is how to know which center has my I-140 petition under the new SCOPS classification for all centers. Now they're tossing these cases between centers. I'm gonna have my team also provide a link that's very specific to answering this question so that you can get more insight on this question. Okay. What is the best path to a green card from a Canadian TN? Best as in speed, but I will also have the option to go back to TN if needed. Something to remember is that a TN has a non-immigrant intent. So when you're applying for a TN and you're entering the US, you're making the attestation that you don't have the intent to live and work here permanently, right? There is a way that you can circumvent that intent. So, for example, if your intent changes after, let's say, 90 days of you getting the TN or of from your last entry into the US, your intent changes, and then you can file for a green card application. Or, for example, you change from that TN to an H-1B. So the best path forward usually is when a person comes under a TN and they're able to switch to another type of visa, like the L1, which has dual intent and allows for people to come into the US, work temporarily, but also stay permanently through another green card application, or to transfer to an H-1B. If none of those are options for you and you wanna come in with a TN, there are several options that you can have if you wanna get a green card application. Again, keeping in mind that you have to be very careful with the intent, and it is not recommended to file for a green card application within 90 days of your last entry into the US or from you getting the TN. Some of the options could be self-sponsoring, right? If you are working in a field or advancing a type of work that's going to be for the national interest of the US, you can explore the path of self-sponsoring through an NIW I-140 application. If, for example, you're also at the top of your field and you have public recognition, you have served on panels, you're commanding a salary that is higher than those who are in your field, you're getting a lot of attention, you're a trusted expert in the community in regards of your field, you can also explore doing a green card through the EB1 process. As an individual of extraordinary ability, you don't need a sponsor. Now, if you do have a sponsor and the sponsor is willing to sponsor you for a green card application, you also have the option to do that and either go through the PERM labor certification process. But again, in terms of timing, that could take up to 2 years to have the labor certification approved. Or let's say you were a manager abroad with the same company or a subsidiary of a branch, you can transfer to the L1 if no more than 3 years have passed since you last held that role abroad, and you need to have held that role with, let's say, the Canadian company for at least 1 full year in the managerial capacity. You can transfer to an L1. You don't really have a waiting time. You don't have a backlog. And the L1A, especially for managers, mirrors the requirements for the green card, which is under EB1 for multinational managers. And you can recycle all the information that you used to apply for the L1. So you do have different pathways, but it depends on a lot of factors, right? Like if you're seeking to self-sponsor, if you have a company that's willing to sponsor you, how much time you have. So if you want to know more specifics about your career path, you are welcome to schedule a consultation with one of our attorneys, and we're happy to provide you with a more tailored consultation. I changed visa statuses from H-1B to B2 due to a layoff, and then back to an H-1B. Do I need to get my new H-1B stamp if I travel? I have an old visa stamp from a previous employer valid until 2027. So this is actually a very popular question that comes up a lot. If you have a visa stamp, a sticker on your passport that's valid until 2027 for an H-1B category, you likely don't need to get a new visa stamp, right? So when you travel, I just recommend that you travel with, let's say your visa stamp is in an old passport, to always travel with that visa stamp, with the old passport or the current passport, and to also travel with the new approval notice from the new employer. So when you come into the US, a CBP officer will check the visa stamp, which is the sticker, see the validity, given that it's in the same classification, H-1B, you likely don't need to get a new one, and then show your approval notice to show that you have permission to stay and work in the US. When you enter, the officer will give you an I-94 record, which will tell you until when you can stay in the US. Something to keep in mind, though, is to check the validity of your passport before thinking of traveling, because some people get their status truncated with the I-94. So let's give you an example. A foreign national has a valid stamp that expires until 2027. They just got a new H-1B approval notice, which extends their status for 3 more years, so 2028. They travel outside and they want to come back into the US. However, their passport is expiring next year, 2026. The officer who's admitting you will give you an I-94 record that will tell you that you only have permission to stay in the US until 2026, even though you have an H-1B valid until 2028, and even though you have a visa stamp valid until 2027. So the way to fix this is that you can get a new passport, do a quick trip abroad to Canada or Mexico, then come back with the new passport, the visa stamp, and the approval notice, and the officer will correct that I-94 record and likely match it to the validity of your new H-1B approval notice. Or if you don't have an intention of traveling, you can always file an extension within the US. I see we're getting a lot of questions in regard of traveling for the holidays. So the next question we have here is, can I travel abroad for the holidays if I have a pending green card approval, or do I need to get advance parole first? So I think this will depend on whether you have valid underlying status. So for example, if a person has, let's say, an H-1B, and they have an H-1B approval notice valid for 3 more years or 2 more years, and they have a valid visa stamp for the H-1B, but they have a pending adjustment of status application, they're likely able to travel outside of the US using their visa stamp and come back in because they have the underlying status. However, if someone doesn't have underlying status, let's say their H-1B expired, maxed out, but they have a pending adjustment of status application, they will need to file for advance parole, Form I-131, and they cannot depart the US until that I-131 gets approved, because if they depart and they don't have underlying status and they have a pending green card application, the government will likely see this situation as you abandoning your green card application, and it will deny the green card application, and you will not be able to get back into the US until you either get a new visa or you get a new status and a corresponding visa stamp to enter back into the US. Okay, we have another question about traveling. Is it safe to travel outside of the US on an F1 STEM OPT status? If you have your valid F1 visa sticker on the passport, the visa stamp, if you have all your documents from your university, from your DSO, and you are still enrolled in the university, and you are able to also prove that you can cover your expenses during your studies in the US, it will likely be safe. Again, just keep in mind that if you have arrests or any criminal history or any violation of status, that it is important that you consult with an immigration attorney, because when you come into the US with all the valid documents that we just discussed, you have to remember that you're seeking admission into the US again, right? So you're making the attestation that you still qualify and that you're still admissible. So it is important, if you have any of these issues, to speak to an immigration attorney before leaving the US. Okay. Okay, so my F1 is expiring on January 5th, 2026. Just got approved for a STEM OPT until 2027. It's a good idea to travel to my home country for the whole month of December and return right before the sticker expiration. If you have a valid visa stamp, and as long as you don't spend 5 months outside of the US in a continuous manner, you're likely able to come back into the US. To play it safe, I wouldn't come back into the US too close to the expiration day or your visa stamp, because you run the risk of, let's say, having flight delays, especially during the holidays and with the issues that are happening right now with airports and the massive delays. And if your visa stamp expires, you are not able to come into the US, you need a travel document, you will likely need to get a new visa stamp at a consulate or an embassy abroad. Okay. So this is a very important question, and I think it's important to check on the embassy or consulate in the city where you're planning to get the visa stamp. We have to keep in mind that even though these are American embassies or consulates, they do respect the local holidays. So, for example, especially during the holidays, it is important to check the office hours of the different cities, because different cities, different countries observe different holidays during the month of November, December, and January, and they might close because locally they celebrate a holiday. So again, it is important to check this. One recommendation that I give clients is that if they have dual citizenship, to check and compare which consulates have a shorter waiting time or which one is operating during the holidays rather than the others that are not, because you might be able to choose the one that is best for you. Okay, we have another question here. I'm a Canadian citizen in the US on an F1 STEM OPT expiring June 2026. My employer prefers I switch to TN in June. Am I able to do this even though I am married to a US legal permanent resident? We don't have an I-130 pending. Likely you will be able to switch to a TN as long as your intent remains valid and clear and truthful, right? So for example, when you apply to a TN, you're going to be making the attestation that you don't have the intention to live in the US. Even though you have a US legal permanent resident, this doesn't mean that you have an intention to be here. Perhaps you have an intention to go back to Canada and live there. So just to have that in mind when you're applying for a visa, as long as you have the right intention and as long as you follow the law and that you perform the activities that are permitted by your type of visa, then you should be fine. I've seen situations for people that have filed an I-140, which is an immigrant intent visa, right? And then they withdraw it and file for a TN. And they had approved the TN and they were able to come into the US and work with the TN. You do have to disclose, again, that you have this pending or withdrawn I-140. But again, as long as at the time that you are applying for a TN, you have the right intent and you're going to follow the law and you are going to do the activities that you're permitted under your visa, you should be fine. I am planning to marry my US fiancé. So is it possible to apply for a B2 visa for tourism? Her family will provide sponsorship. I have no intention to stay here and leave after, and I applied for that 130. Okay, so again, I think this question is related to the question that we had before. Just because you have a US citizen spouse or an LPR spouse doesn't necessarily mean that your tourist visa will be denied, right? As long as you have the right intention and as long as you follow the law, you should be fine in this situation. When you go to your appointment, they will likely ask if you have any family members in the US. And you do have to disclose, right? Like that you have a US fiance. But as long as you make the intent clear that you don't want to reside in the US, at least at this moment, and that you're able to show that you have a strong ties to your home country, like bank statements, that you're working, that you own property, or that you have a business, then you really shouldn't have a problem in applying and probably getting an approval for a B visa. What documents do I need to re-enter the US if I'm on an H-1B, H-4, O-1, or L-1 status? For this type of work visas, it's very important to have the first thing, a valid travel document, which in this case will be a visa stamp, that the sticker that they put on your passport, to check and make sure that that sticker matches your underlying status. So for example, if you're trying to enter under an H-1B, make sure that your visa sticker is an H-1B visa stamp and that your underlying status is valid, right? Because like I said before, the H-1B visa sticker could have a validity, but it's tied and it depends on your underlying status. So even if the H-1B sticker has a validity of 5 years, but your underlying status has expired, you will not be able to come back into the US. So for a work visa, you need your visa stamp, sticker, you need your approval notice for the last application that you have, either H-1B, H-4, O-1, or L-1 status. And you, for example, if you're under an employment visa like H-1B, where you're the main applicant, or O-1 or L-1, make sure that you also carry an employment verification letter with you and copies of the last 3 months of your pay stubs to show that you have maintained status in the US. And don't offer these documents unless an officer asks to see them. So this is the best approach, to just wait until the officer asks to see these documents and then just offer them. I am on an H-4 visa and I'm doing my master's. My husband lost his job and our H-1B ends on January 4th. Can I know what my options are to OPT so that I can continue my master's? So in terms of the H-1B, also remember that your husband has a 60-day grace period where he can start looking for new employment for someone to sponsor him on the H-1B. He doesn't need to re-enter the lottery, right? So if your husband is able to find a new employer, the new employer can file for a change of employer using Form I-129. Then you're able to continue with your H-4. In terms, if your husband is not able to find new employment to continue with the H-1B, then you have to explore visas that will allow you to continue your studies in the US. And as we know, one of the great options is the F1. You will need to speak to your DSO to see if you have fulfilled the time of full-time academic taking classes, right? To be able to meet the requirements to apply for OPT. And if you are working, just keep in mind that if you're working on OPT during your program, this time will be deducted from the time that will be allocated to you if you get work authorization after you graduate. If I'm on a Canadian TN sponsored by my employer and decide to marry a US partner, what's the timeline and steps to change to a green card that allows me to continue working without a gap? Okay, again, I think one of the most important things, especially for people that have a TN, is just to keep in mind the intent, right? And the intent question comes up not only when you get the TN or when you get the last time that you get an extension, it also comes up when you last enter into the US. Because when you're entering under the US with a non-immigrant intent visa, you're making the attestation again that you have no intention to live here. So in terms of the process and timeline for applying, I would recommend to wait at least 90 days from your last entry to apply for the I-130, which is the petition for the spouse. And concurrently, given that your spouse is a US citizen, you don't have a waiting time, right? Like you can apply concurrently for the I-130 and for the I-485, which is the application for adjustment of status, or also known as green card. And you can also apply for a work permit based on the pending green card application and a travel document. In terms of processing times, for some reason, we are seeing the approvals for the work permits related to marriage green card applications come really fast. I would say I've seen cases that come within 3 to 4 months. And then you can use that work permit temporarily until your green card gets approved. Once your green card gets approved, you don't need a work permit. You can just work based on your legal permanent resident status. So this is a question that's very important. When people travel, or even when people are in the US, I want them to always look at 3 documents, right? Their visa stamp, which is the sticker on their passport and tells them that they're able to come into the US, their approval notice for their underlying status, and also their I-94. Because like I said before, if your passport is expiring soon and you enter the US, the officer will truncate the validity on the I-94. And they will shorten the time that you're allowed to be in the US to match the expiration of your passport. Again, you can quickly fix this by getting a new passport, doing a quick trip abroad, and then re-entering with your valid visa stamp and your valid approval notice. And the officer will update the I-94 record. Okay. Following up on my last question, I've been told that I have a good shot at the EB1A if I file that as well as an I-130 through my LPR spouse. Will I still be in the clear to get a TN, or would that be riskier? So in terms of the TN, like I said before, it's very important to think about intent. So if you want to pursue either the I-130 based on your spouse or the I-140 based on the EB1A, keep in mind that it is likely recommended to apply for either of these green card application or visas not earlier than 90 days from the last time you either obtain your TN or you enter the US. So you come in the US, wait about 90 days, your intent changes. Now you can go ahead and pursue either the I-130 or the EB1A. When you apply for either of these applications, again, right, like as long as you have the right intent and as long as you don't have a violation in your status, you likely will be able to get an application. Now you're saying, what will happen if you file one of the green card application type of visas, either an I-130 or I-140 before, and then you try to apply for the TN? It will be riskier because when you apply for a TN, they ask the questions if you have ever applied for an immigrant petition. Immigrant petition is either an I-130 or I-140, and you need to disclose that. So that will raise some red flags for the officer, and they will raise the scrutiny and ask, hey, how can you say that you have the intention to only be in the US temporarily when here in the record we're seeing that you have an open and pending immigrant visa, and the likelihood of getting the TN denied could happen. Will traveling during the holidays delay my pending case? If you have a pending I-485, I-130, and I-140 application. Again, as long as you have, I think it depends on the stage where your application is at. So for example, if you have an I-485 application that's almost at the interview stage, or you have already went to the interview and you're just waiting for the approval, that could significantly delay your application, or you could face a risk of possibly being deemed abandoning the application. If you are not towards the very, very end of this process and you do have valid underlying status and a valid visa stamp, you're likely able to travel and not have a delay or a negative issue or impact on your pending application. For NIW, for F1, what type of achievements, evidence, and recommendation letters that carry the most weight, the optimal timing for filing while maintaining F1, or OPT? This is a really good question. It comes up a lot, especially for students that are trying to take ownership of their own immigration status and history in the US, right? Like they're no longer relying on waiting on an employer or staying tied to an employer and exploring avenues of self-petitioning like the NIW or the EB1 based on extraordinary abilities. In terms of the NIW, I know that sometimes, especially students, think about this and they pause because they can't really work for other employers or they think they cannot build their portfolio. But there are many ways where students under an F1 can actually build their portfolio to make it very strong to be able to apply for an NIW. So I think in terms of what type of achievements, evidence, and recommendation letters carry the most weight for these type of applications, it really depends on the field and the area that you are trying to propose the endeavor, right? So for example, for someone that's, let's say, doing energy, they're working within the energy industry, you could publish work, you could show the direct impact that your work is having for the national interest. So for example, you can show pieces of contracts between, let's say, your employer and a government agency, right? That shows that they're actually requiring you to work for them. Or, for example, if you can start looking for publications or articles or news articles that talk about how renewable energy is saving millions of dollars to the US every year, and because of a specific type of turbine they're using or type of technology, and you're working on that type of technology, you can provide the articles and then make the link from the work that you're doing to the articles so that you can show, hey, look, my work is actually impacting the US in terms of economy. Now, going to recommendation letters that carry the most weight, I usually tend to tell my clients to stay away from recommendation letters from supervisors, current employers, former professors, co-workers. They don't carry as much weight and they actually hurt your credibility. So in terms of when it comes to choosing who will be writing the letters, a good attorney will likely, and I recommend this as well, is having your attorney write these recommendation letters for two reasons. The first reason is that the recommender is probably not an attorney, an immigration attorney, and they're not thinking about meeting the legal requirements when they're writing the recommendation letter. Number two, your chances of getting a very prestigious professor writing you a recommendation letter is so much higher if you tell them, hey, my attorney is going to take care of it, and they're going to write the letter. You just have to put it on the letterhead, obviously accept it that it's true, and then sign it. They're more likely to recommend you rather than if you go to a very busy professor and tell them, can you write me a recommendation letter? Now, in terms of choosing the people, having a variety and a diverse group of people is very helpful. So, for example, professors, industry leaders, people that work in nonprofits, people that work in the industry that are aware of your work and how your work is impacting the industry. That would be a good number. And I would think 5 to 7, no more than 8, 9 letters. Sometimes people think that, oh my God, if I provide 20 recommendation letters, I'm going to increase my chances of getting an approval. Remember, officers are very busy. They're not experts in your field. So and they're people, they're humans, right? So if you provide 5 very strong letters from diverse sources, from trusted sources, and make it easy for the officer to approve your petition, your chances of getting your application approved are so much higher than providing an application with 20 or 30 recommendation letters. Imagine how not happy the officer is going to be that he has to read 20, 30 letters, right? Saying the same thing. So just keep that in mind. And again, in terms of overall, what type of evidence is best to support your case, I would think about metrics. Think about metrics. Think about charts. Think about ways that you can measure in a concrete way your contributions to your field. Even if your field doesn't involve STEM or science, you can still find this information. Like a lot of companies keep track of the data, right, on how the work is impacting the industry. Ask for this, look into it, and this will be very helpful for your case. We answered this one already, so we're going to move to the next one. For EB1, EB2, if my work has been covered by publication awards, but I am not mentioned explicitly by name, can I still use those examples as evidence? How many examples are required for a strong case? This is a really good question, and I think it depends on the type of application. So, for example, for an EB2 NIW, you're not required to have publications, right? The main requirement of this type of application is to show that your work is for the national interest of the country. So you can have zero publications, but let's say be working on a technology that's directly being used by the US military. That is a great way to meet this requirement without having publications. Having publications help, of course, because you're showing your impact, but it's not a requirement, especially if you have an advanced degree. If you don't have an advanced degree, then you have to prove that you have exceptional ability, and having publications then carry more weight. So it really depends on your case. Now, in terms of how many examples of evidence can you provide, it's a balance test, right? So, for example, if you have evidence, very strong evidence that meet other criteria, the number of publications is not as, the need for a lot of publications is not as needed. But if you don't have as much evidence for the other criteria, then having publications will really help offset that. Now, specifically for the EB1, for extraordinary ability, you have to remember that you have to meet 3 of the criteria. And again, same thing applies, right? Like if you have very strong evidence, let's say like you've done a lot of panels, and you can show that you're a trusted expert in the field, that people go to you when they need an expert at a conference, publications are not really as required. But if you don't have the strong evidence for the other criteria, then publications will help your case. Can I travel home and get my H-1B, H-401 visa stamp during the holidays? So this depends on the embassy or consulate where you're trying to apply. Like I said before, different embassies and different consulates in different cities have different processing times, waiting times, closure times, depending on the local holidays. So please plan ahead and don't assume that there is going to be availability at a consulate or embassy in your city if you're trying to get a visa stamp. And I think that's it. I think we have answered all the questions. Just take a quick look. And again, just to remind everyone, we're offering free consultations with an immigration attorney here at Manifest. So make sure to go to our link and schedule your consultation. Our attorneys are very experienced. We have an average of 10 to 15 years of experience. We have seen it all. So it is best to provide very specifics about your case so that the attorney can provide you with a more tailored experience. And these consultations are free. So let's take the last question. The last question here, what are the best sources to refer for high salary criteria for the EB1A? Usually the best sources are anything that's published by the Department of Labor. So if you can find, they have a handbook as well, where they list the occupations, the required degrees, and also the area. And you have to keep in mind that you have to compare your salary within the area where you're working, right? Because a salary for, let's say, San Francisco is not the same for a city that's going to be in the middle of the country or a country that's not as populated, right? We know that salaries are higher in San Francisco or New York City. So make sure that you compare your salary with other professionals that have similar educational credentials in your area. But I would say definitely the Department of Labor has the best sources. Okay. You have a follow-up question, right? So do performance bonus counts towards the high salary? So in the requirements, if you go to the requirements from the USCIS website, they talk about remuneration, right? So likely, yes, it will count. So if you can put a package together showing how you command not only a high salary but high remuneration, that could also be included when you make your argument. And let's see. Okay. We can move to another question. I know we have two more. Okay. As a Canadian, I'm going to switch from my F1 OPT to a TN. Is it better for me to do it ahead of time through USCIS filing or through a US port of entry? It will depend on your goals. If you don't have the intention to travel outside of the US, you can just do the change of status here in the US to TN. But if you have no preference, depending on the port of entry, and again, monitor the port of entries because officers, CBP officers, have full discretion. And let's say your petition for TN, the very same petition could be approved at one port of entry if they have, more, if they're more amicable to TNs, or deny at another port of entry where the scrutiny is higher. So try, if you want to do a port of entry application, either at an airport or a land border, try to monitor, try to look up in the internet, try to ask questions to see the experience of prior applicants and what they're documenting and saying. Because if you can find a port of entry that's actually has a high approval rate and is making things easier for Canadians, then doing that at port of entry is faster and more cost effective because you don't have to file Form I-129 and pay for the filing fees for USCIS. And I think that's it. Well, thank you so much, everyone, for attending today. And please remember that we're providing free consultations, and we also have a lot of resources on our website. We're working on blogs daily, updating information daily. So anything you want, any questions that you have, we're here happy to answer.